Good afternoon, everyone. It is now 2:30 and we are live. Thank you all for joining us for today's presentation. My name is Jaleesa with Legal Aid of North Carolina's Helpline. Today we have Susan Yanagi presenting for us. If you are unfamiliar with the format of this event, Susan is going to review a PowerPoint presentation. At the end of the presentation, we'll have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comment section on Facebook. We'll review all questions put in the chat boxes during that Q&A session at the end. Please remember that this is a public forum and legal aid is not representing you at this time. Susan will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot provide any specific legal advice to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Susan to get us started.
Good afternoon, everyone. As stated, my name is Susan Yanagi. I'm a staff attorney at the Charlotte office, and I practice family law. And today we're going to talk about filing for a civil divorce. Okay. So a little bit of background about legal aid. So we are a statewide nonprofit law firm. We provide free legal services in civil matters to low-income individuals in order to ensure equal access to justice. By civil matters, we mean eviction, domestic violence protection orders, those types of issues. Criminal law, we do not specialize in because we have public defenders primarily for that reason. So it's only civil issues that we assist in. So here are a couple of the areas of law that our attorneys practice. We have housing, employment, education, domestic violence, disaster relief, consumer issues, Medicare/Medicaid, healthcare signups, government benefits, veterans, legal issues, human trafficking, and immigration issues. If you need services beyond this clinic, you can just call the number that's listed on the screen, or you can apply online at legalaidnc.org. This is what the webpage looks like, just so you have an idea. And we're going to dive right into this presentation. So before we begin, I am not here acting as your attorney. Legal aid is not acting as your attorney. We are simply walking through the process about how to file for divorce pro se. I'm going to be using that term several times throughout the presentation. Pro se means representing yourself without an attorney present. And so what this presentation will do, it's designed to help you file on your own. And we'll walk through whether or not filing is right for you, gathering information as to what you need in order to file, how to fill out those forms, how you can file those forms, because right now it currently varies by county, and getting the actual divorce judgment signed. So first and foremost, is a simple divorce right for you? In order to get a simple divorce in North Carolina, you need to ask the following questions. So have you or your spouse lived in the state of North Carolina for at least 6 months on the date that you filed the simple divorce? This is so North Carolina can have jurisdiction. If you've both lived here for 5 months, you can't file in North Carolina. You have to wait until at least one of you has lived in the state for 6 months. If the answer is no, wait and file until one or both of you have lived here. And then the second question that you'll need to ask is, have you been living separate and apart for an entire year prior to the date you are filing? North Carolina requires that you live separate and apart, what we call a year and a day, before you can file for an absolute divorce. And this means like you can't have any try again periods. You have to stay separated. So if you're separate for 6 months and then, on month 7, you decide to try everything again, but then, in month 8, you realize it's not going to work. We really should be separate. The clock begins to run again. You can't just pick up where you left off. That timing for that year begins in that 8th month. So just keep that in mind before you file for divorce. You cannot have lived in the same house during this year. You have to live in separate homes, not separate bedrooms, separate homes. Okay, so remember, no try again periods, no reconciliation, and you can't live in the same home during that year. So something to keep in mind, an entry of a divorce judgment will affect your rights to property division, equitable distribution, spousal supports, post-separation support, or alimony, meaning your money. So if you have any type of property, if you want to divide it, if you want to divide money, or you want to seek some type of support or alimony from your spouse, you will need to speak to an attorney before you file anything. These matters typically need to be handled by an attorney. You really can't do this yourself, so you will want to seek guidance if that's something you want. Just to keep in mind, a simple divorce does not have any impact on your custody rights and the children you share with your spouse. If you want to file for custody, that's a separate action. And a simple divorce does not have any impact on child support. Again, that's something that you would have to file separately. So what information do you need in order to file for a divorce? So the information that you will need about you is your full legal name, your current address, have your marriage license on you because you're going to need to know the date and the place where you were married, and then obviously on the date it happened. You'll need your children's full names and birth dates if you share children with your spouse. And by children, we mean children that are under the age of 18. Okay. And then know the location of the courthouse that you are in, the county that you are going to file in, because you may have a couple questions that you'll need to run by them. So it's important to know where that location is. The information that you'll need to know about your spouse is your spouse's full legal name, their current address, and if they have any type of military status, active, inactive, or whether or not they've ever served. Other things you'll need, and again, this will depend on the county, but you'll need a printer or a way to take files to be printed out somewhere else, like at a FedEx or an Office Max or something like that. You'll need to know a location and payment for a notary public. Check with your clerk's office. Some courthouses may have a notary that can notarize inside the courthouse. I know Mecklenburg County does, but ask that question before you assume. And then obviously a location of a post office that's close to the clerk of court, because you will be needing to mail documents after you file them promptly. So there are two ways to file. The first is downloading all the forms. And then the second is North Carolina Guide and File. And so first going to downloading all the forms. There's a long list of them that you will need. And I believe we have a packet on our website that includes a possible copy of that complaint, of a sample complaint. But you will need to have a copy of the complaint for divorce itself, the civil summons, which is the instrument that is used to serve the other party, a domestic civil action cover sheet, and then the Service Member Civil Relief Act affidavit and petition to proceed as indigent. And we'll go through all those forms again, but those are the forms that you will need to download. A lot of them are available on the nccourts.gov website. You can also use the North Carolina Guide and File program. So what this program is, it's a 1-hour interview survey that gathers all the information and essentially fills out the forms for you. The interview will be shorter if you have all your information ready at the time you go to fill out the application. Once you're done, you'll print out all the forms that it generates, and then you'll file those forms with the clerk of court. So a lot of counties require now the guide and file. So that's why you'll need to know where your clerk of court is in your county, because you want to ask them specifically what are they looking for. But it's still okay to download the forms and file them in most counties. So just check in with your clerk of court. So this is what the eCourt Guide and File looks like. I highly recommend using this. It's a really simple method and it's really easy to use. Again, you can answer online questions. You find the link on the nccourts.gov website. It's free and you can stop and start as needed as well. All right, so walking through filing a divorce using the North Carolina Guide and File, that's the case that was used. That's just for your information. But again, you can also alternatively download the forms at North Carolina nccourts.gov. And there's a tab there that says forms. You go ahead and you click on that, and it'll take you to the place where you can look up the forms you need. So the forms, what do we need? The complaint form, you'll find this again at the legalaidnc.org website. You will also need the civil summons form, the AOC-CV-100 number. That is the number that you can look up on the nccourts.gov website. Each form that's created by NC Courts or AOC is given a number. That's how you look them up. So that's why we have those numbers there. And you can type in the form number on the form lookup site on the North Carolina Judicial Branch website. You will also need the domestic civil action cover sheet, the Service Member Civil Relief Act affidavit. And we say this is optional. The petition to proceed as indigent. We say it's optional because in order to file for divorce, if I can remember correctly, it ranges, I believe it's $200. I believe it's between $150 and $200. If you do not have that money to file for divorce, that's where you file a petition to proceed as indigent. And we'll talk more about what the requirements are for that petition as we go along. And then, or you can file an affidavit of indigency. Again, it depends on your jurisdiction. And make sure you check with your county about any extra forms that they may require. These are the standard, but some counties require other things. So make sure you check with your clerk of court. All right, so you're now ready to file if you have the following. The complaint, 3 copies of those. The domestic civil action cover sheet, again, 3 copies of those. Civil summons, 3 copies. You get the idea. You need 3 copies of everything. Some counties require 2 copies of the civil summons to be printed on yellow paper. Check with, again, your clerk for any county specific rules. You will also need 3 copies of the Service Member Civil Relief Act affidavit, but you'll only need 2 copies of the petition to proceed as indigent. All right, so when you get ready to file, make sure you don't sign anything too early, especially if it needs to be signed in the presence of a notary. Make sure you have all the necessary numbers of copies and all the documents are signed in front of a notary when required before you go and file. Otherwise, they won't allow you to file the documents. And then finally, go to the clerk of court in your county. You'll hand them all the paperwork. They'll file stamp it, assign you a case number, and then they'll hand a copy for your records back to you. They'll keep the original, but you'll get a copy back for yourself, and then you'll get a second copy, and that's the copy that you're going to need to serve on the defendant. And so in order to serve the defendant, you can do it a multitude of ways. You can do it by sheriff or certified mail. Sheriff, in order to serve it by sheriff, it's a $30 fee. What they'll do is they'll go out and they'll try serving the defendant at the address that you provide on your civil summons, and then they'll return it to the court. Sometimes they may return it to you for you to file to the court. So make sure you're checking with the sheriff's department that you need to reach out to in order to determine what the expectations of yourself will be. Or you can file by certified mail, which is through the post office with that a green return receipt that the defendant has to sign to show that they've been served. Lastly, you could also serve by publication, but you can only do that if you've tried serving by sheriff or by certified mail first. The defendant has to get 1 copy of the complaint and 1 summons to be properly served, and there must be proof in the court file that the defendant was served. So you have to return that return of service to the clerk if you do it by certified mail, or if the sheriff doesn't return it to the court for you. So sometimes this process can be done at the clerk's office. You just let them know if you want to serve by sheriff, you want it served by sheriff. They'll put it in a basket that'll go down to the sheriff's office. Sometimes you have to physically take it to the sheriff's department and ask for civil process. If the defendant lives out of county and you want it to still be served by sheriff, you're going to have to contact that out of county sheriff's department to see how they would like you to get the documents to them. Again, you're going to give them 1 copy of the complaint and 2 civil summons. There is a $30 service fee unless your filing fee is waived. And then the deputy who serves the defendant will note the time and date on the back of the summons and will send that back to the clerk. And you can call the sheriff's department to check on when the defendant got served. Some counties have online systems where you can check there as well. I always say call. You're going to get more information that way. And if there are any issues, they can tell you what those issues are so you can try and correct them. And then you will need to know the date the defendant was served. That's very important because all of this is about timing. So you'll need to ensure that you have that date on hand. Certified mail, again, you're going to place one complaint into civil summons in an envelope, take it to the post office, ask the post office what document or what materials you need in order to mail something certified, registered mail. They'll give you a green card and you'll need to fill out the defendant's name and address. The green card will go on the back of the envelope and your address will go on the front of it. So it will be returned to you once the defendant has signed it. Once you get that green card back, it will need to be filed with the clerk of court. And so you will do that once you receive it. And there's going to be an affidavit that goes along with that, but we'll talk about that a little bit more now. So this is the affidavit of return of service. So once you get that green card back, each county's looks different. There's also an AOC form on the nccourts.gov website. You just type in affidavit of return of service under the form search bar and it'll appear. Be careful. There's one for custody alone, and then there's one for just general civil matters. You'll need the one for general civil matters, but you'll need to fill out this affidavit of return of service by certified mail. It will need to be notarized, and you will need to attach the green card that comes back to you to this document in order to show the clerk of court that the individual has been served. And then you'll take it, you'll file it with the clerk of court, and make sure you keep a record. My recommendation is you only need one copy to file with the court, but bring two so you have one for your records. Sometimes we have cases where, people are both on board with getting a divorce. They're amicably separating, they're amicably moving through the process. So this is something that can happen. An acceptance of services is something that can happen in those situations. So this is where the defendant, if they are willing to say, yep, I want a divorce, I accept being served, they can fill out this document and you can, your spouse will need to get it notarized and you can file that with the clerk of court and that will count as service as well. But again, remember to do 2 copies. I actually recommend 3, one for you, one for the court, one for the defendant. That way you all know he or she has been served. You have a copy of it to know the date and to just have for your records. And again, this isn't something you can force your spouse to sign. This is something that they need to be willing to sign. So I mentioned publication earlier. Publication is the last resort regarding service. So essentially what this is you tried doing all the things. You tried serving them by sheriff. You tried serving them by certified mail. You can't get the defendant served. Either they're avoiding service or maybe they don't live at that location anymore. But you know that they live in the county that you're filing in. You can serve by publication, which essentially means you put a notice in the countywide newspaper once a week for 3 consecutive weeks, informing the defendant that you're filing for divorce. They have by such and such a date in order to respond. And then once it's run in the newspaper, they'll send you an affidavit stating that it was posted in the newspaper. It was posted by publication for the statutorily required time. And then you would end up filing that affidavit as well as another affidavit telling the court that you have attempted service by sheriff or certified mail. You've done internet searches to try and find the defendant. You've contacted their family or friends. You've gone through DMV information or tried private investigators. You essentially did everything in your power to try and find them, but you couldn't, so you had to use publication. And typically, some courthouses do have that document available, but it's maybe something that you'll need to draft. So just keep that in mind as well. But there are certain counties I know that do have a local form that they can allow you to use. And then always contact the clerk to see if there are any requirements before using publications. Some courts are very specific, so make sure you double check. So the entry of judgment, after you have completed all the steps, you filed your complaint and supporting documents with the clerk of court, and then the defendant was served, you can file a motion for summary judgment, and you can get that judgment that says you are officially divorced. So the divorce can be entered before the clerk, uncontested testimonial divorce before a judge. Those are the two ways. The procedure for an entry of an absolute divorce may vary from county to county. Again, contact your clerk or family court to determine if there are local rules, forms, or customs applicable to the county where you filed for your divorce action. Judgment of absolute divorce essentially means before the clerk simply means that you've gone through all the steps. You file a motion asking the court to issue the judgment of divorce. The clerks make sure everything's in order and it gets signed off on, and boom, you're divorced. Some courts require a hearing, where it means you have to go before the judge, tell them the date that you separated, the date that you filed for divorce, the date that the defendant was served, and ask for that divorce to be granted. Testimonial divorce hearings. So you must wait at least 30 days from the date that the defendant was served before asking the court to have the case heard. That's for either situation, whether or not the clerk's signing off or whether you have to have a hearing. The defendant is entitled to 30 days to respond from the date of service to your complaint for divorce, meaning they can file an answer or a counterclaim if there is any property, anything like that. You need to give them that amount of time. I say wait 33 to ensure that those 30 days are met and there's no wiggle room or there's no argument that maybe you waited less than 30 days. So wait at least 33 days before you file your motion in order to have a hearing. Again, on day 31 or after, contact the clerk's office to determine what date your divorce hearing can be set. You will need a notice of hearing and a certificate of service, and you have to mail a copy to the defendant. Check with your local clerk of court to find out the specific process and forms required in your county. And then you'll need 4 copies of any of the documents that you're filing for a hearing before a judge. Again, make sure you mail a copy to the defendant. This doesn't need to be served by sheriff. After you have the complaint, after you file the complaint and the defendant's been served, pretty much everything going forward just needs to be mailed, regular old U.S. Postal Service mail, okay? Doesn't need to be served by sheriff going forward or certified. So a notice of hearing gives the defendant the date that the hearing will be held. Some counties only conduct divorce hearings on particular days of the month, not every day. So make sure you're providing the defendant with enough advance notice. And then you must provide your spouse notice at least 5 business days prior to the hearing, but include 3 additional days for mailing if you do end up mailing the document to them. You can hand it to them if you're on good terms. If not, you're waiting 8 days. That you need 8 days in between, essentially. If you don't provide your spouse with sufficient notice of hearing, this may result in the judge not hearing your divorce that day and continuing your case. So when in doubt about dates, it's typically better to add a few extra days to ensure that your case will be heard on the date that has been set. So for a testimonial divorce, you're going to prepare the following documents and bring them to the court the day of your hearing, which is the judgment of absolute divorce, a certificate of absolute divorce or annulment. This you can find on the nccourts.gov website, in a stamped envelope with the defendant's address on it, so you can mail a copy of the judgment of absolute divorce to the defendant. You'll need 4 copies of the judgment of absolute divorce and 1 copy of the certificate of absolute divorce or annulment. And you will need to fill out these forms on the computer and print copies to take to court. We have only provided sample forms as part of our packet. So the hearing, Again, bring 4 copies of everything. Dress business casual, so don't show up in sweatpants or pajamas. I've seen it done. Judges don't like it. So when in doubt, black pants, shirt, white shirt. Boom, there you go. Arrive at least 15 minutes early. Judges do not take kindly to individuals being late, so make sure you respect the court's time by arriving early if you can. Sit on the bench and wait for your case to be called. And when your case is called, approach the judge's approach where they're directing you, either a table or witness stand or wherever, to be sworn and affirmed, meaning that you're putting your hand on the Bible or not, and you're just stating that you swear to that you'll tell the truth. You'll take the witness stand. And that's where the judge is going to ask you, what date were you married? What date were you separated? When did you file for divorce? Have you lived separate and apart? Where do y'all live? Do you want this divorce to be granted? Yes, yes. All of those. Do you have any minor children together? Names and dates of birth. When you're testifying, remember to speak slowly and clearly so the judge can hear you. Also, there are recording devices in the courtroom in order to ensure that the record is taken down. So those recording devices will need to be able to pick up your voice just in case, down the line, anything needs to be appealed or you want a copy of the audio recording for yourself for your records. And then use the judgment of absolute divorce as a guide for your testimony. It basically states everything that the judge wants to know. And it just follow that as a guide. So this is what a judgment for absolute divorce typically looks like. So it's letting the court know that you are a resident of whatever county in North Carolina, the defendant is a resident of whatever county of North Carolina, that either one or both of you has been a resident of North Carolina for more than 6 months. And it will also ask about minor children, date of separation, date of marriage, all of that. This is what the certificate of absolute divorce or annulment looks like. Again, this can be found on the nccourts.gov website. You are just filling in the plaintiff's information, defendant's information, and the marriage information. You're not filling out any of the information that's below that, especially where it says certification. That's for the clerk. You're going to need to know your date of marriage, the place where you were married, and then the date of separation in order to fill out this form. Once the hearing is complete, the judge will then determine if your divorce should be granted, and then you'll send it to the defendant if they are not there. Make sure you complete the certificate of service. This tells the court that you mailed a copy to the defendant. And so after your hearing, mail a copy of the judgment of absolute divorce to the defendant via U.S. mail. Keep a copy of the entered judgment for absolute divorce in a safe location along with all your other important paperwork, because again, this says that you're divorced. If your judgment included a provision for a name change, you'll want to obtain at least 2 certified copies of the judgment in order to provide that to Social Security and the DMV. And again, this is the get help information that we brought to the beginning of the presentation. But before we finish up, I do want to talk about the documents that you're going to need to be filing just really quickly. Again, the complaint, it's very self-explanatory. You're putting where you were, where you currently reside, North Carolina County, or wherever you reside, the defendant where they reside, and a couple terms that you'll need to keep in mind. The person who is filing is the plaintiff. The person who you're filing against is the defendant. And so anywhere you see on the documents that say plaintiff, put your name. Where you see the defendant, you're going to put your spouse's name. The documents will also ask what county you're filing in. So you're going to want to put, a lot of them have a little space next to the word county for you to jot down which county you're filing in. So if I'm filing in Mecklenburg County, I'm obviously going to put Mecklenburg next to that word. Before you get ready to file, anywhere where it says file number, you're not filling that out because you don't have that file number yet. So you'll need to wait for the clerk to provide you with that file number before you fill that out. And typically they fill that out for you when you go to file. I said that petition to proceed is indigent. We talk about that a little bit more. So again, petition to proceed as an indigent essentially is telling the court that you do not have the funds to file for divorce. You don't have the 150 to 200. I think it's 225 now. But make sure you check with your local clerk's office. You just don't have, you're just not able to pay that. And so this form essentially tells the court that, and it tells them why. Either you receive SSI, TANF, food stamps, or disability. That automatically gets your fee basically waived. If you're being represented by a pro bono legal service, you can check that box and the fee will be waived. Or you can simply say, while you don't receive, food stamps, SSI, or disability or anything like that, you just simply can't afford the filing fee, and just be prepared to tell the court why, like your monthly income, where your bills, where your money essentially goes bill wise, if you have to pay a ton of money in childcare, or maybe you're not working right now. Maybe that's something that you're dealing with. So the court will want to know all of that, and the clerk will make a determination as to whether or not your fee will be waived. And again, this applies to the fee for the sheriff's department, but just double check and ensure that that's the case before you just assume that going forward. And so those are the main points. And again, if there's any other questions that you may have, or if you need assistance in any of the other areas that we specialize in, feel free to give our phone number, our helpline a call, or again, you can apply for help at legalaid.nc.org. And that's all I have.
Thank you, Susan. And now we're going to open it up for questions. For anyone with their hands raised, please be aware that you can't unmute in this forum and would need to type your question in the Q&A box on Zoom or the comments section on Facebook. Remember, we can only answer general questions. So it looks like our first question, and this may be too specific, Susan, but I'll go ahead and read it. It says, if you can't find where someone lives and no one they know talks to them, and it's been almost 4 years, it's something about they have papers from the clerk of court, but no address. What should you do?
Right. So if that's the case, you're going to have to do publication, but you will need to exhaust all efforts to try and find them first. Like if you do like peoplefinder.com or DMV records, or even voting records, actually, that's where I have found a lot of people. Pick an address, try and serve via sheriff, try and serve via certified mail, but you're likely going to have to go to publication. And if you believe that you really don't know where they are, they could be in the county you're in, they could not be, you can file that notice of publication in the county where you have filed for divorce. And that should count as service, but you still will need to walk through all those steps before you can do publication. And you'll need to explain everything in your affidavit that you provide to the court. It can be done. It just takes a little bit. It takes a lot extra effort, unfortunately.
Okay, I'm not seeing any more questions at the present. We can just take a few moments to see. Oh, here's a question here. It says, can I use the simple divorce packet from the courthouse if I have minor children?
Yes, there should be your at least from what I've seen at a lot of at a lot of courthouses that do provide a packet, there is a section for you to write down your minor children's names and dates of birth. You can also add an addendum always to whatever you're filing. You can add an extra number and say, please see attached addendum, and you can put together during the marriage, we have these many minor children under the age of 18, list their names and dates of birth.
Okay, I don't see any additional questions at the present. We can take a few more moments to see if any additional questions come in. Okay, so as I'm not seeing any questions, thank you all for joining us today, and special thanks to Susan for presenting. If you would like to review anything that we talked about today, we have posted the recording on today's event to our Facebook. It will be immediately available. You can access this with or without a Facebook account at www.facebook.com/legalaidnc. If you would like to register for one of our other listen and learn presentations, such as expunction, Medicaid, and Social Security, you can do so on our website, legalaidnc.org/clinics. Have a great day.